Okay, just to box that up, and I'm not just saying the dark things, but I just wanted to also add the fact that, and this is on page 39, the Daily Graphic newspaper, that revenue growth still sluggish, economic recovery, new taxes fail to impress after first 5 months. So it looks like the measures that were put in place hasn't helped. If you compare this period, same time to last year, we haven't made improvements necessarily in terms of revenue collection.
Perhaps because there's a lot of lull in manufacturing.
Is it lie or
no? I said lull. I said lull. L-U-L-L.
Okay, I was just going to say the impacts of the pandemic.
No.
Okay.
I'm saying there's a lot of lull, and what I mean is that there's a downturn, and we are not experiencing growth in manufacturing. And once that's happening, then of course your revenue, it will impact your revenue adversely. All right? Now, one other drain on the economy, which we've all come to appreciate, and so there are steps by government to even introduce legislation, is tax waivers. Ask my brother, Kwesi.
Yeah, but you guys approve it.
No, but it's, look, we are dashing, and a lot of these people are foreign entities. And what we have discovered as a friend to the trade committee is that there are some companies, they come, they register under the Ghana free zones. When it is getting to the end of their time to start paying tax, then they do all sorts of things. Sometimes they wind up and re-engineer themselves. Meanwhile, we would have granted tax holidays to them. And the waivers, we are granting a lot of waivers.
Nobody's holding a gun to your head.
But as a government, so government itself, and I am happy that the initiative is coming from the executive itself, that no, we've gotten to a stage where we have to introduce legislation so that there are clear conditions, there are checklists. We have to tick every box before you are granted a tax waiver. Now, the other part is that, look, Mama V, aside all the talk, this government has gone in for the equivalent of $40 billion. $40 billion in 4 or 5 years. And the impact of $40 billion on this economy ought to have been phenomenal. And we can't see it. And that's the reality. Now, our debt level is 334 billion from 122 billion in December 2016. So they have added, I even think that Atu got it wrong. They have added in excess of 200 billion. Because IMF is quoting 334 billion. Atu is being conservative. He says 308 billion.
On the other side, the president, and this is the front page story, president says that the Fitch Rating Agency has projected Ghana to be the fastest growing economy in sub-Saharan Africa. As it emerges strongly from COVID-19.
When you grew the economy at 0.9 just last year, how is he going to do that?
Others grew at 0.
Oh,
negative.
See, so now we should compare ourselves to people who grew at 0.
But that is why
it is the more reason. It is the more reason why
it's the fastest growing.
You see, it is the more reason why.
If you don't compare, how do you?
It is the more reason why President shouldn't be talking like this. Fastest growing under one.
Well, the finance minister.
Fastest growing under 1%.
Finance minister will be in parliament.
Some grew 0.
So you grew at decimal point 9.
This is coming up ahead of the finance minister's media presentation.
That's
on
Friday.
Thursday. On Thursday, 29th.
Tomorrow next.
So we will be having a lot more conversations, and I guess after his presentation, then we'll try and figure a lot more things out.
Definitely.
Yeah. So, thank you, gentlemen.
Cement is now 55 Ghana cedis. Cement back.
Put it in comparative terms. Don't necessarily.
Please, what does that mean?
You see.
It grew from 20 cedis.
No, if you are putting something in comparative terms, not necessarily even in terms of affordability, I'm talking about. But as of now, it's 55. Compare that probably to when it was, say, 2 cedis, and the circumstances prevailing also at that time. That was it worth it?
Akwesi Kenke is now 3 cedis.
That is why I say you always put things in comparative terms.
gentlemen.
Okay, in context, Kenke is 3 cedis.
So hasn't
From 1 cedi.
Perfect. Kenke has been 1 cedi before.
Yes.
But at that time.
Just last
But
year.
I thought the comparison would be, no, was it?
What? Just last year, Kenke was
No,
1
it
cedi.
was 1 cedi 50 pesos.
Oh, there's 1 cedi.
all of it.
Those are the big ones.
It's all of it. You see, now you are even
That's a big one.
You are not even changing.
That's not the ordinary size.
But we actually not even talk about
The average size is 1 cedi. Now it's 3
We
cedi.
must always put certain things in comparative terms, so that then.
Akwesi,
that is where we can
comparatively,
appreciate
Kenke is now 3 cedis
thank
from
you,
last
If you
year.
don't, you can't come.
Thank you, gentlemen. My next conversation is on, it could change a lot of things in Parliament. You're 137, 137. Yeah. There are 2 very important decisions. One would come from the Supreme Court today. This is the Assin North Member of Parliament. Will, could either affect or not affect his position as Member of Parliament. So we're keeping an eye
Is that
on
what
these
is
2.
before the
No, what is before the Supreme Court is an interpretation that I guess his lawyers felt the High Court could have referred it to the Supreme Court, but they did not. So that decision will be made today, but the substantive judgment is tomorrow. Yeah. So it could have. Meanwhile, yesterday, there was also another situation with the Jomoro Member of Parliament, who has now been given 10 days to produce, the documentation proving that indeed she had renounced her citizenship from another country. So we will see how that goes. Will it still be 137, 137? We've got a report on the back of this. Central Region correspondent Richard Kojonyako will join us. He will give us all the backstory so that it will help you appreciate where we are now with these matters.
So,
in the case of the Assin North MP, his appeal was for a stay of proceedings after the trial judge, Justice Kwesi Boakye, dismissed earlier appeal for stay of proceedings. Unfortunately for him, the appeals court he turned to also dismissed the application. Counsel for the petitioner raised a preliminary objection to the motion for stay of proceedings on the grounds that the Court of Appeal lacked jurisdiction to grant motions for stay of proceedings since CI 132 has revoked Rules 27A and 28 of CI 19, which were the rules upon which the Court of Appeal could grant an application for stay of proceedings. Counsel for the Assin North MP, Justin Teriwaja, argued the Court of Appeal's power to stay proceedings doesn't mean that it can no longer grant application for stay of proceedings. He further submitted that it only means that the court's power to grant application for stay of proceedings is now based only on the inherent jurisdiction of the Court of Appeal. The panel of 3 judges unanimously dismissed the application of the applicant for stay of proceedings. The judges then advised the Assin North MP to test the law at the Supreme Court in respect of his contention that despite the revocation of the rules, the Court of Appeal still has inherent jurisdiction to grant motions for stay of proceedings. The MP for Jomoro, on the other hand, had also filed an application to stay execution of the High Court's order on her to produce document evidencing the renunciation of her alleged Ivorian citizenship. Lawyer for the Jomoro MP, Godwin Eduji Tamaklo, says his client, the MP for Jomoro, has never pleaded any such document, so the High Court erred in ordering the MP to produce a document which the MP never pleaded. The Court of Appeal subsequently dismissed the appeal, directing the applicant to apply to the Electoral Commission of Ghana for a copy of the statutory declaration she attached to her document when she filed her nomination to contest the election. Representative of the applicant in the Assin North MP's case, Richie Tichimensa, says his opponents are only seeking to drag the process.
We know from day one that we put a solid case before the courts, and they are going to determine the case on its merit. But from day one, the MP for Assin North and his lawyers have been employing delayed tactics. So even when they know that the application is not granted in law, they will still embark on it just to delay the case. But as I've said some time ago, and it's been said over the years, the wheels of justice grind slowly, but it shall definitely get to its destination. So tomorrow too, we are going to the Supreme Court. They filed an application there for certiorari and interpretation, and that one to appearing before the Supreme Court tomorrow.
The Supreme Court is scheduled to give its ruling on Tuesday in an application filed by the Assin North MP. The MP invoked the supervisory jurisdiction of the Supreme Court on the interpretation of Article 94(2)(a) and to quiet the orders of the trial court judge because, according to the MP, the judge did not allow oral submissions in the case before him. Meanwhile, the High Court in Cape Coast has slated Wednesday, 28 July, for the judgment in the Assin North MP's case. For Joy News, Richard Kwejenyako, Cape Coast.
And Richard Kwejenyako joins me because that Tuesday he was referring to in his report is today. That big decision by the Supreme Court. Richard Kwejenyako, a very good morning to you, if you can hear me.
Good morning, Mama V.
I hope you're well.
I'm doing well.
Okay, great. So, first of all, let's do a recount of where we've come from. A lot of people will remember events of 7th of January because we're told court officials wanted to serve some documents on the MP. But let's go back even to the primary days because issues were raised even there and bring us to where we are today.
Okay, so Mama V, the incumbent MP then was the MPP Member of Parliament for the area, Abnadua Mensah. And so when the context was up, the NDC felt that George Achikwesin, in fact, he won the parliamentary primaries. But even there were issues with the same dual citizenship. And so we're told that the party national executive, the regional executive met over it and then queried him over all of these things. But we didn't know how it ended. And so when he filed between the 4th to the 9th of October, the Electoral Commission opened nomination for the parliamentary aspirant to file their nomination. The now Assin North MP filed to contest the 2020 parliamentary election. So a few days to the elections, there were a series of press conferences and a petition to the Electoral Commission about the dual citizenship of the Assin North MP, George Achikwesin. They wanted Mr. Kwesin to be disqualified, but the EC did not grant their wishes. And so he went ahead to campaign and subsequently won the December post, beating the incumbent Abnadua Mensah. On the 4th of January, a resident of Assin North, Michael Ankumanimfa, filed an interlocutory injunction, and this was on notice and had both counsel for the applicant and then counsel for the respondent arguing their cases in court. And so that case was heard on the eve of the 7th of December. So we remember the drama that surrounded it. So the court here granted the interlocutory injunction. And in fact, the applicant was praying the court to place an order of perpetual injunction on the MP elect because he held dual citizenship at the time of filing to contest the elections. And so the wishes of the applicant were granted, and so the court ruled that the MP elect then, George Achikwesin, should not hold himself as the MP elect, so he would be sworn in Parliament. So remember all the drama and the brouhaha surrounding it in Parliament because there were all of them were battling for numbers to attain the majority in Parliament. And so they went ahead, and then subsequently, Mr. George Achikwesin was sworn in. After that, no one cited Mr. George Achikwesin for contempt because the orders of the High Court in Cape Coast were disobeyed. But you know that the court cannot, on its own motion, go in and then cite anybody for contempt unless their jurisdiction is triggered. Then the substantive case was called. Issues of capacity were raised against the applicant, Michael Ankumanimfa, but it was dealt with. The judge ruled that Mr. Nimfa has the requisite capacity to bring that action in court. So they were back and forth, and so the Assin North MP first had Mr. Kojuga Adaudu as a lawyer, and so he exited, and then the fort was held by Mr. Abraham Hamaliba. The argument went on, but there were no oral arguments that were admitted in court because, according to the judge, the facts of the matters were known. Documents that were supposed to be tendered in evidence have all been done, and so it would amount to a waste of time, since they say that this is an election petition and time was of the essence. It got to a point, it got heated, and so there were near fisticuffs at the High Court. The judge then ordered the two counsels for the petitioner and the counsel for the respondent to walk out of his court, because they were making the court ungovernable, for want of a proper expression. They came back and then the case went on. But the main issue that is in contention is Article 94(2)(a), and so it's been interpreted differently by both counsels. So lawyers for the petitioner argue that Article 94(2)(a) kicks in when the person initiates the process to contest the election. And so at that very moment, between the 4th and the 9th, when the EC opened the nomination and they went in, there was a form that the MP filled. And so he filled that form and responded in the affirmative when he was asked whether he held dual citizenship or not. And he answered that, well, he did not hold any dual citizenship. And so at that point in time, the MP had not gotten his renunciation certificate. In fact, he got the renunciation certificate on the 27th of November, a few days to the December polls. The other argument that is being advanced by the counsel for the Assin MP indicates that, well, it actually kicks in when a person is being sworn in Parliament. That is after the elections have been conducted and the person is being sworn in. That is where Article 94(2)(a) kicks in. And so they thought that it was too ambiguous and then it needed some interpretation from the Supreme Court. And that is why they urged then the High Court judge to stay so that they could go to the Supreme Court for interpretation. But the judge indicated that that matter is as simple as anything and it requires no interpretation from the Supreme Court, and so went ahead to do that, citing, in fact, the counsel for the applicant cited a lot of cases, and at the end of the day, the judge took the decision that they are not going to send the matter to the Supreme Court. And then during the pendency of this application, there were issues of bias. That was on the 12th of April, issues of bias that were raised against the judge, according to Mr. Ibrahim Amalbam, the lawyer for the Assin MP. Then he said that the judge had prejudged the matter, or there were some prejudicial comments made by the judge, and so if they allowed him to still continue to handle the case, the justice will not be served. So that also came up. And then Mr. Abraham Amalba was asked to produce records or support his claim or allegations with evidence, and we are told that he couldn't submit or support his evidence, his claim with any evidence. And so that plea or that appeal to the judge to recuse himself was dismissed. That did not end there. He also petitioned the Chief Justice on the same matter, on the issue of bias. The Chief Justice went through and said that, well, since he's unable to show any evidence indicating that the judge, in fact, prejudged the matter by making some comments, then he said that he even went ahead to give them some legal advice, some routes to take. They could take the matter further to the appeals court. The appeals court will handle it. And so it went back and forth. And Mr. Amaliba indicated that, well, he could not be a party to such an enterprise where the judge sitting on the case had already prejudged the matter. And so he asked that he would not be the lawyer for the Assin MP again. And so the legal processes ought to be triggered so he stays away from the case. That took almost 2 months because getting even the MP to be served to notify him that indeed the lawyer that he hired says that he can no longer hold the fort for him was an arduous task. The EMX, the bailiff, and we were told that they went there twice, and the indication was that Parliament was in session, and so the member of Parliament cannot be served. So Mr. Abraham Amalba came to court, and then the argument was that, okay, well, since you relate directly with him and then you give him correspondence every day when you come to court, then we are tasking you to do that. But Mr. Malba came back and said, well, it's been very difficult getting that. And so the necessary legal processes were triggered, and then a new lawyer was found, and then he came to stand in. In fact, they were also told that they should also submit their or make available their written submissions. And up to date, the lawyers for the Assin MP have not submitted the written submissions. The others, the Electoral Commission, and then the applicant, they have all done so. And so the date was fixed for judgment. And so when the date was fixed for the judgment, there was an indication that another application had been filed to the Supreme Court where they were seeking several things. Two of them prominent that they were seeking interpretation of Article 94 2A, where they expected the judge to have referred the matter to the Supreme Court. And secondly, they are also invoking the supervisory jurisdiction of the Supreme Court in that the trial judge did not allow them oral submissions. And so they want the Supreme Court to quash the decision that has been made by the trial court so that they would allow them to advance some legal argument. And so here we are today. Is the day where the Supreme Court set 27th of July for its decision on the application that has been filed by the Assin MP. And then tomorrow being Wednesday, the court had to adjourn because it adjourned. The judge said that he's only adjourning because of the respect the High Court has for the Supreme Court, and so they would allow the Supreme Court to go ahead with the decision. And then on Wednesday, they come back to court, depending on what the Supreme Court will say.
Okay, so that's a lot that you've unpacked for us. Thanks, Kojo. But let's also talk about the Jomoro situation, because there was a development yesterday from the Court of Appeal.
Well, so with respect to the Jomoro situation, there was a ruling of the High Court in the Western region ordering the Jomoro MP to submit documents of his renunciation to the applicant and then the other parties involved. And then he said that the judge ruled in error, and so he came back to the appeals court. But when she came, the appeal was dismissed on the grounds that he should go to the Electoral Commission to secure documents about his renunciation or the declaration form. So the necessary parties would be given these documents. And the appeals court judges actually awarded no cost and said that could be done. And so they should liaise with the Electoral Commission to furnish those documents. But lawyer for the Jomoro MP, Eduji Tamakulu, says that since the documents were not pled or they were not in the pleadings of the Jomoro MP, they do not find reason why they should be ordered to produce such documents. And so that case was also subsequently dismissed. And so they go back for the substantive matter to be continued. Okay.
All right. When is that? When is the date for that continuation?
In fact, I've lost track of that particular date in the Jomoro case.
All right. We'll keep our viewers updated, though. Richard Kojonyako, thanks a lot. That's our Central Regional Correspondent, bringing us up to speed with the matter involving the Assin North Member of Parliament and the Jomoro Member of Parliament. These decisions are crucial because, as you know, MPP in Parliament is 137, same with the NDC. The only difference that gives the MPP an upper hand is an independent candidate who is on their side. So these decisions will be crucial. We'll keep an eye on the Supreme Court today and certainly give you the very latest. As and when they make a decision on the matter that's been referred to them, we will bring that to you. We've got show business news, the last thing we do before we wrap up the show, so stay with us.